Hello everyone, welcome to System of Rules. My name is Revathi. Today we are going to discuss law, definition of law, functions and purposes of law and the sources of law. Law is a set of rules and regulations. Law is uniform in nature. It has certain amount of stability and uniformity. Powers of making law lies in the hands of the state. State passes those laws which are considered to be for the human welfare. Law in its widest sense means and involves a uniformity of behavior. Law means justice, morality, reason, order, rightness, etc. from the point of view of society. Law means statutes, acts, rules, regulations, orders, ordinance, etc. from the point of view of legislature. Law means rules of court, decrees, judgments, orders of courts, injunctions, etc. from the point of view of judges. Now we move on to the definition of law. According to Salmond, the law may be defined as the body of the principles recognized and applied by the state in the administration of justice. According to Austin, a law in the strict sense is a general command of the sovereign individual or the sovereign body, issued to those in subjectivity and enforced by the personal power of the state. According to Austin, law is the aggregate of rules set by men as politically superior or sovereign to men as politically subject. He says that a law is a command which obliges a person or persons to a course of conduct. According to Savinci, he says that law is not a body of rules set by a determined authority, but are rules consist partly of social habit and partly of experience. The next topic is function and purpose of law. Law is an instrument of society, and its objects are achievement of justice, stability, and peaceful change. The ultimate purpose of law is justice. Salmond says that law is the body of principles recognized and applied by the state in administration of justice. As in the case of stability, it is also known as uniformity. Law must aim at stability in society. To achieve stability, a balance has to be struck not between persons but between interests. That is, to achieve the stability in the society, a balance has to be struck not between persons but between interests. Okay? The third is peaceful change. It is also known as flexibility. It can be also said as social control. The existing rules may not provide solution to the case of changed times, and no rule can prove for every possible case. There is need for flexibility. Flexibility is necessary to enable the law to adapt itself to social change. Now we move on to the next topic, sources of law. There are three sources of law, that are custom, legislation, and precedent. First one is custom. Custom is the rule of action voluntary and uniformly observed by the people. It embodies a rule of conduct approved and accepted by the community for generations. Custom is to society what law is to the state. So custom is of slow growth. Second choice of law is the precedent. A precedent is a statement of law found in a judicial decision of a superior court, meant to be followed by the same court as also by the subordinate courts. There are some merits and demerits of precedent. The merits are they bring certainty in law. Yes, that is true. And the second one is they bring about a scientific development in law. And the third one is they guide the judges. There are some demerits also, that is an extremely erroneous decision is established as law due to not being brought before a superior court. And the second one is the development of law depends on the incidence of litigation. And the third source of law is legislation. The term legislation is derived from the Latin word legislatum, which means law-making power. Legis means law and the latum means to make. So it is called law-making power. The law-making body is called legislature. Legislation is the most potent and the sovereign source of law-making. It is the only source which has all the powers of enacting law, repealing old laws and the modifying current laws. All modern civilized states of the world are giving more importance to legislation through which laws are made for the guidance of the members of the state. Legislation is the rule passed by the legislature which is binding on all the individuals in the society. The legislation is the making of law by formal and express declaration of rules by some authority in the body politics, which is recognized by the courts of law as competent for the purpose. Legislation may be supreme legislation or subordinate. That is, it can be classified into two: supreme legislation and subordinate legislation. Legislation is said to be supreme legislation when the authority under which the law is enacted is a supreme authority or a sovereign law-making body, like a legislature of an independent and sovereign state. According to subordinate legislation, it is also known as delegated legislation or indirect legislation, and may take any one of the following forms: ordinance, order, bylaw, rule, regulation, notification, and statutes. Thank you all. Thank you so much for watching this lecture class. In our next class, we will discuss the difference between substantive law and procedural law.